Good evening, guys. I hope all is going well for you. It's Ken again from Corporate Medical Emergency Training. Spending a little time with you this evening, just trying to wrap up some more of your compliance programs as far as your training and your virtual training that you need to be doing as per your employer. And tonight we're going to finish up with the last two videos in our series. The first, we're going to talk a little bit about sexual harassment in the workplace. Although your employer already has a program set up, which they're required actually by law to provide you a copy of your sexual harassment policy, as well as policies on what to do should you feel that you have become a victim of sexual harassment, and the policies as far as filing a complaint. And when we have to resort to that, it's a pretty serious charge when we accuse someone of that. So we'll talk a little bit this evening in my lecture to you about you want to make sure you have certain things in order if you have to go that route. And we'll go over that. But your employer has to provide that for you. And most of you have had that probably in your onboarding when you first came to work for your employer. But it really doesn't hurt to touch base on this time and time. As with all of the OSHA programs that we are providing for you, you know that you're required to do that annually every year because things change. Currently, there is no mandate that I'm aware of that says you have to do sexual harassment training every year, but that's something that your employer can mandate. And your employer basically can mandate really anything for you if they feel that it's important, it's necessary, it protects you, and it protects them. So when we refer to sexual harassment, we do need to know who the EEOC is, and most of you do know who they are. But if you don't, the EEOC is the Equal Employment Opportunity Commission, and they are usually the agency in charge of setting rules and policies and laws, telling employers what they can and cannot do, what they are not allowed to discriminate against, as well as providing any type of offensive material or treating anybody differently based on sex, because it is deemed as sexual harassment. There is harassment, and then there's sexual harassment. And the two different types of sexual harassment that are recognized by law in our country, in the United States now, the first is called quid pro quo. And then the second is called the hostile work environment. And those are probably the two main terms or terms that I'd like you guys to discover what the definitions and answers are to that. Because if we know the two different types of sexual harassment, whether it's quid pro quo or it's a hostile work environment, it really prepares us better to come to work. Because the one thing we want to do is we definitely want to try to keep our behavior neutral, per se, because we don't know sometimes if we maybe are telling a joke and we don't really mean for it to be offensive, if it's not sexual in nature and that's not our intent, we may not realize that we actually are creating a type of sexual harassment, because sexual harassment doesn't have to be physical. It doesn't have to be touching. We know touching someone inappropriate is sexual harassment, but it can be verbal. It can be through gestures, eye contact, different types of faces that we may be making at someone to show them that we're very attracted to them and that we're interested in possibly engaging in some type of sexual behavior. So there's all different types. And of course, one of the others today is sending offensive material on the internet and sending inappropriate pictures and offensive material to people through their email. Certainly, corporations today and employers would never tolerate that, and that's usually grounds for immediate dismissal. But again, these particulars are always covered in your corporate or your employer's policy if you don't work for a corporation per se. So I urge you to check with your human resources department and make sure that you're provided a copy of what their policy is and what to do if you become a victim. But let's give you a little bit more explanation on the two different types of sexual harassment and how we relate to them and what they mean. So quid pro quo. I always have a hard time saying that. It sounds like such foreign language to me. But quid pro quo is basically the type of harassment that we can use the phrase in saying something for something back. We're doing something for somebody because we want something back. We're trying to be nice to an employee. We're a supervisor. And maybe there's a physical attraction there. Maybe we think that there's a possibility that we may be able to get some sexual favors out of this individual, when in reality, people really should realize the chances of that are pretty slim. And the way to go about it is definitely wrong. And we need to educate people that not only is that not acceptable, but it often backfires. So an example would be a supervisor is extremely nice to a certain employee, lets that employee take more time off and get paid for it, possibly gives them a promotion, maybe someone who's more experienced and is in better position to get a promotion that can handle the job is passed over by that supervisor because they want sexual favors from someone else. And here's where it gets interesting. If the employee who is being harassed through quid pro quo knows that they're being harassed and they refuse to take part in this and they refuse to accept the favors from the supervisor, it usually goes the other way, and then it can sometimes turn into a hostile work environment. And that's the second type of sexual harassment. So the employee is being harassed and is being intimidated and is being made even more uncomfortable coming into the workplace because the harasser is not satisfied. They're not getting what they were hoping to get in return. So here's where we start to see maybe more cases coming out. And a good example of that I like to use, and we're not mentioning any names for privacy, but we all know with our recent New York State governor that he was accused of sexual harassment, and there were multiple female victims who came forward and accused the governor of sexual harassment. So interesting, I ask myself and ask you guys the question is it possible that he was actually doing quid pro quo and it didn't turn the way that he wanted, and now he created a hostile work environment? We don't know. We don't know all the facts. We do know that he was given an option to resign, which he did, and of course he was never prosecuted. But interesting that he had numerous cases, because often in a hostile work environment, it's more than one isolated case. And sometimes there's a history with the accuser. With the accuser, maybe they've been involved in more than one case. But with the harasser, there's sometimes a history, and it does involve many cases or many complaints. There's usually a pattern of behavior there. So, and other types of sexual harassment today, we know, can be, you intentionally brush up against somebody. You purposely want to rub up against them. Or there's some type of inappropriate touching that may be going on. And we live in a different world today. We need to be more aware of it. We need to always keep our behavior neutral, because that keeps us on our toes and it keeps us more aware of the possibility that we may end up creating or actually practicing a form of sexual harassment, which was not our intent. I actually had an instructor work for my company for a couple of years. He was a good instructor, and I had a corporate client, and we have had some corporate clients, although we primarily specialize in dental and healthcare. but we still have the client. It's a big accounting firm of ours, and they have offices across the country. It's a national contract. And they are like, I believe they're like number 4 or number 5 in the top accounting firms in Cranes, New York business. If you're not familiar with that, that's a publication that goes out and they rate big corporations based on their revenue, and they're often in Cranes, New York business. So, make a long story short, I had sent him to do a CPR course and train them on how to use a defibrillator, AED CPR training for lay rescuers. And I had been going to this client for years, and they probably got very comfortable with the way that I ran the training and the way that I did it. And I've always been concerned about building relationships and always been concerned that when we have members of the opposite sex, sometimes in corporate America, some females may be in dresses, they may be in skirts, they may not be comfortable going onto the floor and practicing on a CPR mannequin. So obviously, we have to make flexible options for these individuals, and we do that. But this individual was doing a course with these people who I'd known for numerous amount of years and numerous amounts of training that I had done for them. And his style was different, so they weren't real pleased with his style. They were comfortable with the way that I teach. And something was said. It was never told to me what it was, but 3 of their female VPs in the accounting firm called me on it and had said to me that if I ever send that instructor back to them again, that they would not renew their contract with us. In fact, they would terminate their contract and that we would no longer have a business relationship. So when I was hit with this, I thought to myself, wow, what was it that he said to these females? What was it that he could have thought that he could get away with saying? Because the director of HR did tell me, she said that what was said was totally inappropriate. So I can only imagine. And he was a nice guy. He was, an EMT, like myself, EMS background. He was a good guy. And maybe he didn't really think that what he said was inappropriate. So I decided actually just to no longer use him again. He was an independent contractor. Instead of, confronting him and causing, all kinds of potential problems. Of course, I did damage control with the client. And of course, I apologized and did everything I need to do. And thank God we still have the client available. But they will not have any other instructors ever come to them. They only want me. So things like that happen. And again, I don't know if it was intentional. But whatever happened, they were offended by it. And that's what we have to concentrate on. We have to think the other side. Again, we may disagree and say what we did or what we said was not sexual harassment, but the receiving party may construe that differently. They may be offended by it. Sometimes it's a cultural thing. We all grow up in different places in the country. We all have different values and different beliefs. So keep your behavior neutral, okay? Now, the other thing that we have to keep in mind is in the event that you became a victim of sexual harassment and you felt that you needed to file a complaint, a couple of things that we want to think about. Number one, if it's possible, confront your harasser. If you're comfortable sitting down with them and talking to them, give them an opportunity to hear you speak to them, because maybe there's a possibility, just like this instructor, if I had spoken to him or sat down with him, that maybe they did not realize what they were doing was wrong. And maybe if they have half a heart in their body and respect for you as an individual, they're going to owe you an apology, and they're going to apologize and admit that they were wrong, and they were going to hopefully promise to never do it again. But if that individual's behavior is so erratic that you as the victim do not feel comfortable sitting down with your harasser, then the next step is to go immediately to your supervisor. Make sure that you have all of the data. You need to have the times, the dates. You should be keeping a record. If this is going on for any length of time, you need to start keeping basically a record, or maybe even if we use the word a diary, if you will, a record of this. Because if it turns into the second type of sexual harassment, which is the hostile work environment, you need to have documentation of this, because it's a possibility that this individual may have gotten away with it before, and there could be more documented cases, or maybe they've already been confronted by HR and they've been given a warning. So just make sure you have all the data. It's a pretty serious charge. So we want to make sure we have all the proof, all the documentation that we need, any witnesses that were involved. If it's a really bad enough case of a hostile work environment, or any type of inappropriate touching, or any type of sexual gestures, and other people hear it, it's a possibility they're going to be witnesses for you. If it's a female and she hears it, she may confront the accuser and say, that was not appropriate to us. It is undermining us as females, and it is not appropriate. If it's a male and a male witnesses a female touching that male, maybe he may come in and say something. So you may have that backup. You may have that data. You may have those people who are willing to be witnesses for you. And you need to make sure that you're following exactly what your corporate policy is. And with all of our training, as you well know, I'm constantly always telling you guys, please check with human resources, check with corporate, check with your supervisors, make sure that we're not telling you anything that's outside of what your employer wants you to be aware of, or that you need to know. So, and we know too that any type of joke when it comes to sexual in nature, any type of pornographic information, that's just not appropriate in the workplace. We don't need to bring that to the workplace. We don't need to have that in the workplace. And even if the individual thinks it's funny, someone else may be offended by it, even if it wasn't directed at them personally. They may find it inappropriate, and they may find it to be a hostile work environment as well. And your emails, we need to keep our emails very, very businesslike. Certainly in large scale companies, like the one you work for, the Smilist, they have an IT department, they have fraud. We're also your HIPAA compliance officer as well. And I work hand in hand with the IT department and setting up your security measures. I actually have access to your HIPAA security, and I go in and I check everything to make sure everything is being done correctly. So if any type of sexual email comes across, or any type of pornographic information comes across, IT is going to pick it up, and they're going to know. They're certainly monitoring emails that are going out. So we need to be aware of all these things. Make sure when we come to work that we understand what quid pro quo is, that it can also, it's number one. Number two, it can lead into a hostile work environment. Those situations absolutely are inappropriate in the workplace. And I'm sure that your employer will provide you the necessary steps to make sure that you feel safe in the workplace, and that if you feel that you were passed by for a promotion, or that you were not treated fairly, I'm sure that your HR department is there to help you. Their job is to help you in HR and set policies to keep you safe. But if you experience anything like that and you're not sure, as with anything, if there's ever an OSHA incident or anything that we've been training you and teaching you on, I urge you to give me a call. We are not an employment law firm, so to speak. We're not attorneys, so we're not going to speak out of what we're qualified to tell you. So what we are telling you right now is exactly the steps for you to take in the event that you feel something's not right. So you want to reach out to your supervisor and to your corporate department. We know that every employer has a legal department. If it's a large enough size company, there are attorneys and law firms that specialize in sexual harassment cases. So if anything needs to be referred out, your employer would do that. They would more than likely provide you for some legal representation in the event that happened, at your place of employment. So, alrighty. So that's pretty much all I need to go into with you. I could talk to you all night about this. There's no reason to do that. You guys have all had this in your onboarding. As with all of our courses, we are nationally approved for continuing education with the Academy of General Dentistry. So this also will qualify for CE credits, which you can use towards your license renewal, whether in New York, you're in another state, New Jersey, typically wherever you are, we're nationally approved. So I appreciate the time that you spent with me this evening to go over this sexual harassment. I would also encourage you to reach out to the director of HR as well. I know him, and he has worked with us very well in setting up your virtual training, and I'm sure anything that we've not been able to answer for you, he would be willing to answer that for you as well. So, alrighty, guys. So we'll see you shortly. We're doing the last video and the last lecture, which is going to be on the employee alcohol and drug overdose. We're going to be doing that shortly, so you'll see me back for that. And then that will finish up the series of the trainings that you guys will all be required to do. So thanks again, guys. Continue working hard, taking care of your patients, and stay safe. And feel free to reach out to me at any time if you need any of our help. Thank you so much, guys. Have a good night.